Basics of protective orders. Kinds of protective orders. Ex parte orders, divorce stipulations, civil restraining orders, and criminal no-contact bail orders. The most common protective orders we help with are stalking petitions and domestic violence restraining orders. Criminal no-contact orders. These are different from civil restraining orders. They're imposed on the defendant as part of bail conditions. The victim cannot drop the no-contact order because abuse is a crime against the state. A victim also cannot break the order because it's on the defendant. If the defendant contacts the victim, they are in violation of bail conditions and may be arrested. RSA 173B, Protection from Domestic Violence Protective Orders. Who does RSA 173B protect? It must be a qualifying relationship, current or former sexual or intimate partners, current or former spouse, persons now or formerly cohabitating. Other qualifying relationships, child in common, dating or have dated, family or household member, for example, an adult son being stalked and harassed by his father. Important to know, minor children cannot get a protective order against their parents. Parents may seek a protective order against someone on behalf of their minor child, per Jade's Law. If someone was sexually assaulted by an acquaintance or stranger, this could fit under a civil restraining order. Where to file for an emergency or temporary order. Emergency orders are issued outside of court hours through the police department. Police take the information and call a judge who decides whether to grant it. The victim must apply at the court the next business day to get a temporary order. The victim can file for the temporary order at Family or District Court Division, the court where the defendant or the plaintiff live, where the plaintiff is temporarily living, or electronically through a crisis center advocate, and it can be transferred to a different court if necessary. Survivors may now file electronically, but they must work with a crisis center advocate to access the forms. The forms must be submitted by email during business hours, Monday through Friday, 8 to 3 only. Filling out the forms works best with a computer versus a phone or an iPad. How is relief obtained? The plaintiff or a victim alleges abuse by the defendant. The plaintiff must show immediate and present danger of abuse. Why are they in fear for their safety now, meaning a credible threat? Under New Hampshire's Criminal Code, RSA 173B, abuse includes assault or reckless conduct, criminal threatening, sexual assault, interference with freedom, destruction of property, unauthorized entry, harassment, or cruelty to animals. For a temporary order, the victim fills out the protective order forms and submits to the court clerk in person or electronically. The judge reviews and decides. If granted, the clerk passes on the decision to the victim with a hearing date. Once the temporary restraining order is served to the defendant, it is in effect. The defendant can expedite, ask for the permanent order hearing within 3 to 5 days. It's best for the victim to keep a copy of the order on them at all times. Both emergency and temporary orders are issued ex parte without the other party present to answer the victim's claims and to put a stop to abuse. Next is the permanent or final order hearing. Permanent restraining orders, or PROs, are issued after a final hearing. This can be telephonic, via WebEx, or in person at court. The final PRO can be issued after the judge hears both sides testify to the allegations in the petition. If granted, the order is good for 1 year. At the final hearing, the petitioner must prove both abuse and that the defendant poses a credible threat to the plaintiff's safety, causing them to be in fear. What is credible threat? Recent acts of abuse per 173B, an ongoing pattern of behavior. Their safety is at risk when the petition is filed, and context matters. The statute supports considering past abuse, but this must be included in the petition. Other considerations. The petition must give defendant proper notice. The defendant must be heard within 30 days or sooner upon request. Court must have jurisdiction to issue the order against an out-of-state defendant. What does a protective order offer the victim? A protective order restrains the defendant from abusing the victim, their relatives, or household members in any way, entering the victim's residence, employment, school, or other specified place, withholding victim-specified property, or contacting the victim directly or indirectly, and protective orders restrain the defendant from taking, damaging, or converting property, acting such that utilities, etc., are discontinued, abusing or destroying animals, and must stay away from the animal. What other relief is available through temporary orders? Award custody of minor children. Visitation is not typically ordered on a temporary basis. Direct the relinquishment of weapons and barring future acquisition. Award exclusive use and possession of the home, car, furnishings if the defendant has a legal duty to support the plaintiff. Award exclusive care, custody, and control of animals. What relief is available with final or permanent orders? It includes all the temporary relief and may order the defendant to make payments for the car, mortgage, utilities, attend counseling or batterers program, and pay spousal or child support. Pay compensation for the plaintiff's losses, such as earnings, injuries, property damage. Pay reasonable attorney's fees. Final orders can be issued for up to 1 year and are renewable for good cause shown. An order can be extended for a year by filing a motion at least 10 days prior to the expiration of the existing order if there is cause. From there, an order can be extended, and each extension would be for up to 5 years. The abuser can file an objection to an extension of the order request, and the judge would hold a hearing to decide. The advocate's role in the protective order process. Things to avoid. We are not lawyers. We don't give legal advice. We don't speak during the hearing. We don't fill out paperwork for the client, and we don't tell them what to write. Advocates explain the general process, help the client prepare paperwork, and put their narrative in order. We go with clients to submit paperwork and can accompany them for the hearing. Advocates also refer questions on criminal no-contact orders to prosecutor's office. We offer to connect the client with free, low-cost attorneys. We help client prepare emotionally and plan for self-care throughout the process.